Hey guys, it's Joel Williams and Chase Elleby at Williams Elleby coming to you today with week number 16 out of our video series of 52 weeks of personal injury. Today we want to talk to you about how to discredit a witness in court, or things to watch out for if you're a witness in court where the other attorney may try to discredit you. So Chase, what's the number one way that we see that people and witnesses get discredited in court?
So the number one way is prior statements, right? So anytime there's a lawsuit or anything like that, there's always depositions that are taken. That's sworn testimony with other attorneys asking questions and things like that to get facts about the case. So when you actually go to trial, if your testimony at trial is inconsistent or different than what you testified to with that sworn deposition that may have been years ago, then you are going to be, what I like to call just kind of burned on cross, basically discredited in your testimony if you're not consistent.
Yeah, and I think also the most common example is definitely deposition testimony, but it can really be prior statements from anything.
Right.
So for example, if it's a car wreck case and you're at the scene of the accident and the police officer has a body camera on and you tell the police officer the wreck was your fault, and then you come to trial and try to say that it was not your fault, then that body camera video footage can make you look kind of silly.
Right.
So prior statements, even in medical records, right? You tell your doctor something, and then you testify differently to it during sworn testimony at trial. It can really come back and make you look like you're not telling the truth, and the jury may not believe you. So the second way that we see that people are discredited are records. And speaking of
medical records,
right. Yep, that's the most common example in a personal injury case for sure, because at least in the state of Georgia, medical records are admissible at trial, and we go to the doctors who knows how many times, depending on what the severity of our injuries are, and we tell them how we feel from day to day. We tell them about our medical history and all of that kind of stuff, and then for example, if you've got if you hurt your knee in the wreck, you got a prior knee condition, you tell your doctor about it, but then you testify at trial that you've never had any problems with your knee before, those medical records can be used to what we call impeach you, which basically means to discredit you at trial. So those records can be used to discredit a witness.
Right.
About number three.
Yeah, so medical records, and another thing, like police reports, right? Whatever you say to the police officer. So any just paper, right? When I think of records, I think of paper. So the third thing is to show bias, right? Showing bias of a witness at trial is another way to discredit them. A good example is, if you're injured and your wife gets on the stand and starts testifying about how great, the guy you were and how this injury's really impacted you, well, the defense attorney's gonna say, well, more likely than not, you're saying that because he's your husband, right? You want him to get a recovery, things like that. So to show bias and to just make the jury believe that you're only giving that testimony because you favor that person no matter what. So.
Yep. And another common example for bias would be employer-employee relationships.
Yep.
If it's an employee of a company, the company's the defendant, then we can suggest that the employee would want to give more favorable testimony for the company because that's their employer.
Hired experts, right? If the defense is hiring an expert and they're paying them thousands of dollars and they've testified for them 50 times before this case, that's how you show bias to this expert. They're going to give testimony that's favorable to the defendant. So.
Yeah, exactly. Another example would be prior crimes that the witness has committed or been convicted or pled guilty to. There are only certain crimes, at least in Georgia. This law probably varies significantly from state to state as to which crimes can come in. But in Georgia, if you have pled guilty or been convicted of a crime involving dishonesty, or a felony where the conviction or your release from confinement was less than 10 years ago, that can come in to show that you might be a less than truthful person. Whether that's fair or not, I don't know. It's just what the law is. So if you do have any prior criminal convictions, just be aware that they may be used to try to discredit you at trial.
Right, exactly. And another way is to raise questions too about someone's ability to recall information. Right, if you get on the stand and you say you can't recall or I don't remember or this, that, and the other, you can use that testimony to really imply, well then if you don't recall this, then how do you actually recall that? You know what I mean? So it's a lot of times people get in depositions and they want to kind of say, well, I don't really know, I don't recall and all that, which if you don't know, you don't recall, that's fine. But if you don't know and you don't recall anything, but you do recall that one specific thing that's very favorable for your case, that's going to completely discredit you.
Yeah, 100%. Let's see, another way would be character for untruthfulness. These laws are really tricky. So, you know, what I'm going to say now is very general and very vague, but just know that there are laws in place, depending on the kind of case that you're dealing with, where people can actually be called to trial to say, oh yeah, everybody knows that Chase is the biggest liar in town, or that, you know, Chase has a reputation for being dishonest. In certain cases, that kind of stuff can come in. Now, that's probably not the most effective way to do it, because the person saying that might be a big old liar themselves.
Right.
But just be aware that in some cases that can come in. So what do you think's maybe the last one to wrap this video up?
Last one, probably when someone opens the door, right? Opens the door to evidence that probably wasn't let in for whatever reason. The judge decided, you know, certain evidence is not coming in, but, you know, the defendant or plaintiff gets on the stand and just talks about something that wasn't supposed to come in, but now that they've talked about it and brought it up, they've opened the door so you can talk about it. An example would be, you know, like maybe in a tractor trailer case where the driver, you know, for whatever reason, the judge decided to keep prior speeding tickets out. And then the driver gets up there and testifies, well, I've never had a speeding ticket or anything ever in my life before. Well, that's opened the door to that testimony or that evidence of prior speeding tickets to now come in that you can use to discredit and impeach that witness.
Yep. Yeah, so that about wraps it up, but just remember there are several ways that attorneys use to try to make a witness look less than truthful. In legal terms, we call it impeachment, but really it just means to discredit the witness or make them look like either their memory is not great,
right,
or that they are, I guess, being evasive or dishonest. So just be aware of those things, and that'll wrap it up for week 16. If this video has been helpful to you, we'd appreciate you subscribing to our channel, giving us a thumbs up below, or insert a comment in the section below, and we'll see you next week for video number 17.